Hello everyone, myself Vaibhav Verma and I am a part of LEXIS and Company as a legal intern. Today I am going to talk about on a topic under Indian Contract Act 1872, that is contract of indemnity. As the word indemnity suggests that repayment against monetary loss or shield somebody from causing a loss. Contract of indemnity is a special kind of contract where the term indemnity literally means security or protection against a loss or compensation. Contract of indemnity has been defined under section 124 of the Indian Contract Act 1872, which state that a contract by which one party vows to save the other from loss caused to him by the lead of the promisor himself or by the direct of some other individual. In simple words, we can say that contract of indemnity can be characterized as a lawful contract between two parties or two persons or two peoples, whereby one party resolves to indemnify or reimburse the loss caused to the next party by the conduct of the party who is making the guarantee or by the lead of the third party. For example, A contracts to indemnify B against the consequences of any proceeding which C may take against B in respect of certain sum of money. So, any kind of insurance insurance policy be a certain example of contract of indemnity. Let's say ABC Insurance Company entered into a contract with Alpha Limited to compensate for loss caused by accidental fire to the company's stock of goods up to rupees 50 lakh for a premium of rupees 1 lakh. This is an express form of a contract of indemnity. So, what is the basic objective of the contract of indemnity? The main object is to protect the promisee against unanticipated loss. Now let's see who are the parties to the contract of indemnity. Number one, the promisor or the indemnifier who promises to indemnify the loss. Number two is promisee or indemnified or repayment holder, the who get indemnified by the promisor. Now see what are the essential elements of a contract of indemnity. Number one element is parties to a contract. There must be two parties, namely promisor or indemnifier, and second party is promisee or indemnified or indemnity holder. Number two essential is protection of loss. A contract of indemnity is gone into to shield the promisee from the loss, and such loss might be caused because of the lead of the promisor or some other individual. Number three essential is expressed or implied. The contract of indemnity might be expressed, for example, made by words or gestures, or it can be implied or suggested, for example, gathered from the direct of the party or condition of the specific cases. Next essential is essentials of a valid contract. A contract, as we know that the contract of indemnity is a special kind of contract. The principle of general law of contract contained in section 1 to 75 of the Act are applicable to them. Therefore, contract of indemnity must also possess essentials of a valid contract. Now let's see what are the rights of the indemnity holder or promisee and what are the rights of promisor or liabilities of promisor. According to section 125 of the Indian Contract Act, the rights are accessible to promisee or indemnity holder against the promisor that or indemnifier if he acted inside the extent of his position. Number one right is right to recover damages paid in a suit. Indemnity holder has a privilege to recover from the indemnifier all harms which might be constrained to offer in any suit in a matter of any issue to which the contract of indemnity applies. That is, any kind of damages which the indemnity holder is bound to pay in any suit concerned with any issue to which the contract of indemnity applies. Number 2 right is any expenses which the indemnity holder is bound to pay so as to bring or defend the suit. And last right is all the amount which the indemnity holder has paid in connection to the settlement of the suit. Now let's see what are the rights of indemnifier. Section 125 of the Act lays down the rights of the indemnified and is quite silent of the right of indemnifier, as if the indemnifier has no rights but only liability towards the indemnified. So we can say that the liability of the indemnifier is, number 1, indemnifier is not liable until the indemnified has suffered the loss or indemnity holder had suffered the loss. And number 2 is indemnity holder can compel the indemnifier to make good his loss although he has not discharged his liability. I hope you like the video. Thank you.